I'm going to go ahead and get us going. We've got a great crowd, and I want to respect y'all's time. So it's Lionel Richie and the Commodore Zoom from 1977. I wish I'd taken their advice and bought Zoom stock just before the pandemic. They are from my old hometown, believe it or not. My youth, I lived in Tuskegee, Alabama, and
Really?
Town Square has been renamed Commodore Square there. They're very proud of that group, who had, of course, an amazing career as a group and an amazing career for Lionel solo. Good morning, folks. I know a whole lot of you that are on this. I'm really excited about this morning's webinar. Any of you that don't know me yet, I'm John Miller, and I own Rock Solid Law and Title. We began doing weekly webinars during the pandemic, and we've continued it monthly since. I'm really thrilled this morning to have a guy who's become a good business referral partner, but more than that, a friend. I will tell you that I consider him brilliant, so I would tell you to listen to every word that comes out of his mouth. This is Chris Sanchez from Sanchez Wealth. Chris, welcome.
Thank you. Appreciate it.
Yeah, man. I know you're a busy guy, and I really, really appreciate you taking the time out for us for this little bit of time this morning. So, guys, you know that Rock Solid Law represents entrepreneurial business owners, closes real property with title and escrow, and does a lot of estate planning with folks. So today we're a little bit more on the estate planning side. And one of the important things that I always say is that for the folks that I work with, if you'll think of a business having a board of directors, each of us individually, whether we think about it or not, have a board of directors. And I would submit to you that the folks that should be on that are your financial advisor, your attorney, your CPA, and perhaps if you have a relationship with an individual banker and an insurance agent, not just the company, but with an individual, those people are your advisors too. It's really, really important that we professionals coordinate together, work together for your benefit. So today we're going to talk about funding, and I have regularly said that if I were king of estate planning, I would have called it retitling rather than funding. Because when people hear the word funding, they think of money coming out of their pocket and going somewhere else. In this instance, it's really moving the title of your assets into your trust. Okay, so that's called funding. And I have found over the years that Chris and his team are among the very best at this. In fact, he's one of the ones that we have discussions back and forth about, well, what's the proper way to do this type of account? So that's one of the reasons that I wanted his expertise on with us this morning. So we've met, think about the client progress. We've met, we've agreed what kind of plan you need. And for this purpose, there's a trust existing. Remember, the trustee only has the ability to control what's in the trust. So the funding or retitling process is putting things in the trust. Now, a bank account, you got to go to your bank and move it, the account from your own name or you and your spouse's name into an individual name. But when you have investments or accounts of certain types, you have to figure out the rules. So I'm just going to ask Chris to give us a narrative on the various types of accounts that we have the opportunity to fund into folks' trust, and why there's some considerations on which accounts we don't title right into the trust and we might attack a different way. Chris, if you'd like to tell us any more about you and your business, lead with that and then launch.
Sure. All right. So my name is Chris Sanchez. I run Sanchez Wealth Management Group. We're a registered investment advisory fiduciary firm in Jacksonville. Been here 30 years. And John and I got together because we take a very holistic approach, not just managing the accounts that we manage for clients, but actually looking at the whole broad picture, which includes balance sheet, income statement, and such. And as part of that, we find an enormous number of mistakes that people make, or some misconceptions about how these different assets should be titled and why, right? So I went and met John a few years ago, and he had a similar mindset in trying to solve problems and have proper outcomes. So it was a really good fit for us. And we communicate back and forth, so you don't actually have to be the person in the middle, right? If you set up a trust, John will forward that information to us. we coordinate proper titling and make sure. So with that in mind, I'm going to start with the most common misconception that I get. People will create a trust and they'll come in and they'll want to move everything into the trust. Well, there's certain assets that can't or shouldn't be in the trust, specifically IRAs and 401ks. As part of our process, we will review beneficiary designations on those accounts at every client meeting because we find mistakes there almost 35–40% of the time. So the first thing I want everybody to realize is that the trust is a vehicle for transferring assets that do not have beneficiary designations. In fact, the trust doesn't control anything that has beneficiary designations. So in many cases, it's the largest assets that you own, and the trust actually has nothing to do with it. So you start with all life insurance, 401ks, IRAs, Roths, annuities if you have them. All of those will pass from the final at death through that beneficiary designation to the person that's listed on there, not the trust. Now, in some cases, we'll name the trust as the beneficiary. But then there's some rules here you have to be concerned with, and that is the new rule with 401ks or IRAs that get distributed not to a spouse, but to a non-spouse, where those accounts in most cases have to be liquidated over a 10-year period of time, unless there's a special need or a minor child or some other things. So it's a fairly complex process. But I think you start with looking at the entire balance sheet, all the assets that you own, and then identifying which one of those pass through beneficiary designations. Make sure you have contingent beneficiary designations set up for that so it doesn't get caught up in probate or worse. And then you look at all of the assets that don't have a way to convey. And that's where the trust comes in. The trust is a vehicle that's used for several reasons. And I always joke, we call them a trust. They really should be called don't trust, right? We really use them, to control the assets beyond the grave, or to make sure these things pass, outside of probate. And you can do a lot of things inside of those trusts, but just remember that in most cases, it's not going to have anything to do with other assets that are controlled through beneficiary designation.
Perfect. And that's one of the points I heard you inference, but not nailed down, and I'm going to do that, is that all those assets that have beneficiary designations go outside of the trust and outside of probate, because our number one game is to keep you out of court, keep your heirs out of court, not bog down the inheritance pattern that you want to set up by being in front of a judge and in front of creditors. So those beneficiary languages, like Chris mentioned on the IRA or 401k, or on a life insurance policy, people don't realize that life insurance proceeds pass outside the trust, outside the probate. Now, you mentioned control from the grave, Chris. If you do want to maintain control from after you're gone or from the grave, then you need to have those run through the trust where we can, those assets run through the trust where we can write whatever rules that you want applied. And I love that, Chris. I've never heard that it should be called a don't trust, non-trust, because really what we're doing is trying to protect the heirs from themselves. I have regularly said that no 18-year-old needs to be in control of $1 million, because our experience is it's gone within a year and a half. And the child lives a life of regret that they blew it, right? So the trust can help with that. Chris,
yeah, a lot of times we'll talk about giving the kids enough money to do anything they want, but not do nothing, right? That's really, that's really the goal of most. And unfortunately, we see a lot of people come into us, for the first time, and they're like, we have a trust. Like, well, okay, great, and we'll read the trust, and it's all fine. And then well, what's in the trust? And they're like, I don't know, we have a trust. And what we find more often than not is that there's nothing in the trust. We have an empty box with a set of instructions, but there's nothing in there. So we'll have to start that retitling process, whether it's the primary residence or it's shares of an LLC, of a real estate company, or even their own business. There's lots of ways to structure it, but it's fairly complex. And I would argue that if you're not the one doing it, your advisor or whoever you're working with should be reviewing that on an annual basis to make sure those accounts are, or those assets are titled properly and they flow through the way that is the most tax efficient, or the way that fits your family's needs the best. And there is no simple formula. It's different for every person. You might have a spendthrift, or you might have a special needs trust, or you might have a daughter-in-law or a son-in-law that you don't trust, and you got to figure out how to sort of work around that. So I think it's different for everybody, but it should be reviewed regularly.
Absolutely. And the latter situation that you brought up is very, very common
Right.
in my conference room. We have to figure out, if our child is gone, how do we get the money to benefit our grandchildren without it being taken sideways by somebody that's come into the family and that you don't trust, to use the same.
Absolutely.
Yep. I'm going to reveal something. Some of you have heard me say it. It's not a popular thing for me to say among other members of the bar. And that is that a lot of lawyers take the position that it is not their role or obligation to help their clients or even educate their clients about funding. And I think this is a very self-serving opinion. The opinion is, well, I can't go to the bank and sign their name, so it's not my job to get it funded. And what happens is there's a piece of paper somewhere in the notebook that has that stack of documents that says, okay, go fund. And the truth is, statistically, over 90% of people will never get that done because they don't understand that they need to.
Right.
It's absolutely imperative that the decision be made on every valuable asset, whether it's in or outside of the trust. And why? Because everything outside of the trust that doesn't have beneficiary language is going to probate. Who do you think makes money at probate?
Attorneys.
Lawyers,
Yeah.
attorneys, accountants, valuators, every professional, and not your kids, not your heirs, not the charity that you wanted it to go to. So we want to keep those funds away from those professionals. For families that we didn't get to plan with, yes, we'll help them through probate, and we're going to do it for a fair but reasonable fee. But for families we get to work with, we're trying to keep them out of that probate. And we're telling them, not only are we telling them to fund, but we actually have a member of our team that does that with every single client that comes through. And I believe, Chris, she's on a first name basis with the members of your team as they do that process together. We can't go to the bank and sign your name for you, but if you do your planning with us, we're going to nag you. We're going to bug you until you tell us, stop it, or yes, I've got it done. And unless it's yes, I've got it done, you don't have a completed plan. You really don't.
So John used the word process, and I think that's really important. It's one of the reasons that John and I work so well together, is that we actually do control that process. So you finish up your planning documents, John's staff will send those through a portal that we have. We'll receive those documents with funding instructions, and then we schedule the appointment with the client and go through beneficiary designation review, which assets go into the trust, which ones are the spouse, the primary, and the trust, the contingent, or whatever again, it's a very individualized thing, but we'll handle that process for them and go through and make sure all that stuff is titled properly. I'm going to share one quick story because I think it really hits the point. We had a client that had come in fairly new and passed away. He had a trust, he had beneficiary designations, had not moved his house into the trust. And his two daughters in their 20s inherited the house. It was in Neptune Beach. It took 18 months to get that house through probate. And in the meantime, they lost the homestead exemption. They lost their primary homeowner's insurance. They had to pay property taxes, electricity, mow the lawn. They couldn't rent it. They couldn't sell it. It ended up costing them about $20,000 plus the additional expenses to get that through. And it all could have been solved by simply somebody looking at it and saying, wait a minute, you have a trust. Let's go on the property tax appraiser's website and see if it's actually titled properly. And of course, most of the time it's not. So then we'll go in and say, okay, you need to go see John, do a quick claim deed. Let's get this transferred over. And then we review that. Every year you come in, you check and make sure, okay, is there anything new? Did you buy or sell? Was it done properly? Most real estate agents, most title companies do a pretty poor job of asking how this is supposed to be titled. They just assume.
Yeah, people come in all the time and think that once they've signed, that magically their assets moved into the trust.
Right.
And Chris, It can't be magically because it takes a thought process for my team and your team to decide which way they should go. I will tell you that if you did your work or do your work with us, your homestead is going to be deeded into your trust unless there's a darn good reason not to. There are good
Right,
reasons, but
right.
we're going to go over those with you. I get asked this all the time, and it's a little tangential, but you do not lose any of your Florida homestead protections by moving your trust into a family living trust. Okay. So don't worry about that. People do all the time. Believe me, we know the many ways that Florida homestead is protected. And I always say that one of our primary jobs is never screwing up your homestead. So we're going to get that. We're going to get that in there, but you'd be amazed at how many don't, and for no good reason. Chris, I want to hit you referenced qualified retirement accounts, IRAs, 401ks, those sorts of things.
Right.
And I think we've got enough time to do a little bit of drill into that so you can help them understand better what the analysis is on how to title those downstream.
Okay, so first off, everyone should know that the spouse to spouse continuation hasn't changed, right? So if the first spouse dies, the surviving spouse takes over the 401k IRA. The rules apply. They take it over as their own. It's subject to their age, not for required minimum distributions, not the age of the deceased spouse. So spouse to spouse is pretty easy. When it goes to the next generation, it gets much more complex. Again, the rules changed. I believe it was 2020, where we went from 70 and a half to 73 and 75 for required minimum distributions, but we lost the ability to stretch it out over the beneficiary's lifetime. In the past, we would write clauses in the trust that said, we'll force out this, we call them stretch. In other words, the beneficiary would get an income stream over their lifetime and could keep that account relatively deferred. That all went away today. There's a 10-year rule. And what we've talked to our clients about is that that's a large burden. If you've got a fairly sizable qualified plan portfolio that's really embedded in taxes, you really have to start training the kids early on how to handle that money, or they may have serious tax consequences, or worse, they'll live really well for a few years and then they're back to poor. So we think of it as a responsibility to our clients to train their kids on how to be a good steward of wealth over time. And we'll show them through modeling, this is what'll happen if you spend it. And then here's what'll happen if you don't. And we use this to build a lifetime of financial security. And that works a lot of times. The statistics are amazing. Most kids will blow through that money in a year and a half. So everything you've spent your life saving and scrimping and building and worrying about, they're going to enjoy the heck out of it for a couple of years, and then it's gone and they're back to where they are. So I think you want to engage the kids fairly early in financial education and the power of money, or what wealth really is. Wealth is not necessarily income, it's the financial security and the income that it produces. I like to use the analogy of the goose and the eggs. If you eat the goose, you're not going to get any more eggs, right? So we like to grow and protect the goose and then live on the eggs for the rest of your life.
I love that analogy. I hadn't heard that one before.
Yeah.
I will note you when I use it, I promise. Carolyn, I saw your note in the chat board. I'm glad this is valuable for you. Yeah, post-death administration shouldn't be so complicated. And the way that it becomes non-complicated is by planning before death.
Correct.
I've regularly had adult children come to me who have said, who have come right after their parents are gone, and that if we had met 2 weeks before they were gone, we could have made things very, very easy. So it's very important to get people in while they have their cognitive ability, right? And obviously while they're still alive. Your power of attorney can't help them after they're gone. I do see some other folks are jumping on the chat, which is fantastic, and somebody on question and answer. So I'm going to go to the question and answer board real quick while we have about 10 more minutes with you guys. And the first one is, if the primary residence is in joint spousal ownership, the spouse will receive ownership at my death. What's the benefit of moving into the trust before then? The risk is if you go on vacation and the plane goes down, then that is going to be subject to probate. So the benefit is going ahead and determining now. Now, there are a couple different ways that that issue can be attacked, and it's a little beyond the scope today to think of the other ones, but there's an enhanced life estate deed available in Florida for folks that don't have a trust. So if you don't have a trust, that's something we want to discuss. But if you do have a trust, there's absolutely no downside to moving that joint ownership to a joint trust. Doesn't affect the spouses or the surviving spouse or the homestead with them, but it sure does take care of the downstream family. Then the other question, obviously I'm reading them first impression. So should a standard checking account where you receive your employee direct deposit be retitled? How about money market? Even if the investment mix in the money market account is both. Okay, Chris, I'm going to give you the second half of that. If you could see, can you see the question and answer on your end?
I cannot.
Okay. The first one is, I do advise people to move their regular old checking and savings and those kinds of accounts into the trust. There's absolutely no downside to that.
Right.
And the living trust is a see-through instrument. We might have a different answer if we were talking about an irrevocable asset protection trust, but we're not talking about that this morning. Just letting you know there are some nuances. So we do advise everybody to move those accounts into the trust name. There are people, particularly older clients, who don't want to have the name of a trust on their checking account. And so we'll make the trust the beneficiary. And that way it moves straight to the trust, and the rules that you wrote within your trust would apply. Chris, the second half of the question, I'm going to read it out loud. How about a money market account, even if the investment mix in the money market account is both equities and cash equivalents?
So the answer there is real simple. If it's in an IRA or a 401k, it's controlled by beneficiary designation. If it's not, it's a probatable asset, right? And I would go a step further. There's the step up in basis that happens at the death of the first spouse. So there's some titling considerations there as well. Even with a house, I think it's prudent at the death of the first spouse to pull maybe the Zillow appraisal or whatever, because half of the value will step up. If you've got a house that's worth 4 times more than you paid for it, you may be getting into an income tax situation later on if you were to sell. So there's the basic rule for us is that unless there's a good reason, if it doesn't pass by beneficiary designation, it should be controlled or titled in the trust. That's not true every time, but
Right.
but most of the time. Now, I had one more piece. One of the things I have found over the years is if you're with a commercial bank, you're with one of the large banks, that it's really important for it to be in the trust. If you're in a credit union, they generally have beneficiary designations or PODs, which will be on there a lot of times, and that can override your intentions. So if you're not reviewing that, most of us opened those accounts 30 years ago. We've been there forever, and we have our parents or our siblings or somebody else named as the beneficiary. You think it's going through the trust, it's not. It's going to go to whoever's named as the beneficiary. So again, I can't recommend enough, whoever you work with, that should be part of your annual strategic review, is to go through the titling and the beneficiary designations of everything on your balance sheet, not just the accounts that the advisor is managing, but every asset on your balance sheet, to make sure that it flows the way you want it to.
Absolutely agree with that, Chris. And that's a great point. You mentioned the credit union account that a lot of people have while they do their banking through some other entity. A lot of times people will forget that little account that they've got for some specific reason. Maybe it's a holiday vacation account, maybe it's a hobby account. And often that will cause either a probate or the heirs to walk away from the account if it's small enough. And, a probate costs money. So the heirs are saying, why would I spend $5,000 to get 6? Well, that 6,000 will go to the government. So that's just an election to pay another tax that didn't really need to be paid.
Right.
Chris, what you said segues perfectly into our next and probably what will be our last question this morning, guys. If you do have other questions that we didn't get to cover today, or there's something you'd like to ask, not on an open Zoom meeting, questions, that's a plural, S after it at rocksolidlaw.com. If it's a question for Chris, I'll absolutely get it to him. If it's a question for us, we'll get you an answer. But this last question, Chris, is how does POD work on a checking savings account? If you have this designation, is it still advisable to move to a trust? And I'm going to give the lawyer's favorite answer. It depends. It depends on how you want that money governed. If you want that to be subjected to the rules you wrote in the trust, for instance, if you don't want them to have it right away, then you would want to designate it to the trust. But a POD, if you name an individual, will go straight to that individual and not be subjected to the rules that you wrote in the trust. You're taking the time to plan, to set out the way you would like to protect your heirs, those people you love the most, with what you worked hard to build. So why not run it through the trust and have it subject to the same rules as the rest of your estate is? The other piece I would just suggest quickly on that is if you blend some PODs, some in the trust, you have a real risk of unequalizing your estate. Let's say you had two kids, you wanted to give it to both of them, but then you just put one of them as a beneficiary on an account, and over the years that account becomes a large amount of money. Well, suddenly that child is inheriting that money directly and half of everything else. So it's a matter of continuing to be vigilant. I love what Chris is talking about, annual reviews, to make sure that you have not forgotten something that might be important to you. So, a lot of times we just set things and forget about them. That's just a human condition. And so the question about, well, should we put the homestead in the trust? Well, if you do that, then you've said it and you can forget about it. You don't have to even ever think about, well, what if we both go at the same time, or one of us has lost our mental capacity and the other one dies? All those what ifs are taken care of by the rules that you wrote. So
we see some other things, John. I'll just go. Okay. I know we only have a minute or two.
Go.
So the administration of this estate, when you're gone, can get very complex too. If you have assets that pass through POD or TOD in the case of investment accounts, those assets will go directly to those other kids or whoever is listed. But the administration of the estate may have taxes or income taxes or other things that need to be paid, medical bills that need to be paid, and that money's gone. It's not available for that. And you're not getting it back. If you give it to one of the kids through a TOD or a POD, it's not in the estate to settle any claims before it gets distributed. So it almost always is going to be unfair in doing that. There is an ability to use TOD as a trust, name the trust through a TOD or a POD, but I don't know why you would do that, but it is possible. There are, again, every situation is unique, and it depends on what you're trying to do.
I don't have a great hypothetical on that, but I agree with you. There could be a good reason to do it. That's why we always talk to everybody and figure out their situation.
Right.
So your takeaways today, friends, is one, you're not done with your planning until it's funded. And you're not done then either, because you need to review it annually and make sure it's up to date and truly reflects what you want it to reflect. Number two is you need a professional team to help you through this, because we all don't know what we don't know. Sorry to say this, but I'm ignorant in the real definition of ignorant. There are things I don't know in this world, and I admit them. And I have people like Chris around me who know those other things and can teach them to me and help me learn them. We're all ignorant of something. I'm a lousy mechanic. I am very ignorant of things that my mechanic knows, okay? Ignorance is not necessarily bad unless you live in a perpetual state of it, as long as you're looking to experts to help you work through it. And then, Chris, I wanted to put you on the spot and ask you if you are available at this point in time for new clients.
So yes, we don't cast a wide net. If it's a good fit, yeah, we usually like to try to get together with folks and see if we like each other first, and then go from there and see, okay, can we help, right? We're not looking to add 100 new clients, but if it's a good fit and we can really make a difference and get them organized and set them on a proactive wealth strategy, and more importantly, solve the risks that they face, longevity and inflation and market volatility and those things. If it's a good fit, yes, but the answer is we don't cast a real wide net.
Yep. And that's one of the reasons Chris and we get along so well is we're looking for more great fit clients and not all of them. And I will tell everybody out there that Chris is at the top of my referral list for the right clients. And I will tell you that I consider my referral list one of the most valuable aspects in my 40-year legal career, and that is to get folks to the right lawyer that they do fit. So, or investment advisor that they do fit. Or I've got everything down to plumbers on my list, Chris. I try to keep folks, keep the good folks employed and not funnel business to the ones that I've seen do not right things. So, guys, for those of you that have worked with us, if this set a red alarm off, give us a call and let's try to fix whatever may be worrying you. For those of you that haven't, I really appreciate your time today. In exchange for that, we would be glad to sit down and talk to you and work through this process and see if we can't be help. Again, if there's a question that was more sensitive than putting it out on the internet, questions at Rock Solid Law.